This presentation is titled Juvenile Justice Policy Analysis, Senate Bill 1391, presented by Ninfa E. Delgado and Yesenia Ruiz Guzman. The policy analyzed in this presentation is Senate Bill 1391, which prevents juveniles ages 15 and 16 from being tried as an adult, even if they have committed murder, because they are seen as rehabilitated by the time they are released at age 25. There is an ongoing debate by those who support SB 1391 and those who oppose the bill. We will delve deeper into both sides of the argument and present some solutions to strengthen the original intent of this legislation. First, let's begin with some background information that led to the passing of SB 1391. The most recent legislation in place on this issue was Proposition 57, which was put into effect by the voters in 2016, passed by a 64.46% approval rate. It gave district attorneys the ability to recommend minors ages 14 and 15 to be tried as adults. Senate Bill 1391 removed this ability to recommend the trial of 14 and 15-year-olds as adults, with no room for exception cases. SB 1391 was signed into law September 30th, 2018, and took effect January 1st, 2019. It is important to recognize the influence of elected officials in the passing of legislation. Governor Jerry Brown believes in rehabilitation, largely influenced by his experience in witnessing his own father, Edmund G. Brown, battle with stakeholder backlash for his then support of executions when he was governor. As such, the presentation of SB 1391 was timely, likely to be passed with Governor Jerry Brown in office. The importance of stakeholders cannot be overlooked. Stakeholders include people or groups of people that are affected by policies, whether directly or indirectly. Stakeholders are influencers who can advocate for or against a legislation. They play a significant role in the policymaking process by identifying the problem, setting the agenda, formulating the actual policy, and legitimizing the policy itself. There are several stakeholders in support of SB 1391. One of those is social service providers. They work with clients from various backgrounds and upbringings. They work directly with the public and are able to see how certain groups, such as minorities or underrepresented groups, are directly affected. Financial struggles is another area where these groups can have shortcomings, as it can lead to an inability to get equal and fair representation within a courtroom. And families as well are unable to provide adequate prevention at home due to a lack of resources. In terms of behavioral health providers, they also treat clients with trauma and they see how it can impact their decisions. A mental health condition, their surrounding environment, and/or background also plays a role. There is much research and practice today recognizing the need for trauma-informed care or adverse childhood experiences and how those impact behavior and the ability of juveniles to make adequate decisions. Specialists therefore feel that the solution is within intervention. You have social justice groups and other advocates such as the ACLU, NCCD, where disparities can be seen statistically through the research that they have done. For example, for every one white youth convicted as an adult, 4.5 Latinos and 11.6 Blacks were tried as adults in a court of law. This demonstrates how minorities can be targeted through legislation and why advocates for youth were against Proposition 57. Social justice groups fight for a fair process for those wrongly convicted or targeted by police, especially those from racially or ethnically minority groups. You also have families of defendants. They do not wish to see their children in prison serving a life sentence for a mistake that they have made. And there's a strong belief that an intervention can help in their rehabilitation. There are also stakeholders opposed to SB 1391. First and foremost are the families of the victims of the crime. They have felt ignored and that their feelings or the impact that they are feeling is invalidated. They worry about public safety and that those who have committed these offenses would repeat these offenses again. And they felt that Proposition 57 worked because the crime matched the sentence that was provided. They believe that not every child can be rehabilitated, especially after committing a serious crime such as murder. District attorneys also are opposed to SB 1391. They have felt the shift in power in the courtroom where they no longer can recommend adult sentencing to minors. They are in favor of rehabilitation, but in the courtroom, they have seen many cases where not every juvenile feels remorse and therefore feel they may not have the ability to rehabilitate. This bill has also been challenged by at least 10 California counties, and district attorneys are gathering together to work towards overturning SB 1391. Law enforcement agencies fear that repeat offenders will be the result of SB 1391 and that justice is not being served by not making the juveniles responsible for the crimes that they are committing at a serious level in being charged as an adult. There's a concern for overall public safety and a fear that crime rates will continue to increase. There are various forms of policy models used in the development of legislation. In the case of SB 1391, a rational model follows the process that was taken. The rational model begins with defining the problem. In SB 1391, the problem identified was the harshness of Proposition 57 and the disparities that it produced among youth of color, where disproportionately youth of color were being tried as adults versus their white counterparts. The second one is identifying alternatives to what is already in place. SB 1391 was what was presented as an alternative to Proposition 57. This would include stakeholder voices and taking into consideration all the possible implications of new legislation. However, it is important to note that there are limitations in knowing what all of the alternatives may be and what all the desires of stakeholders may be as well. Thirdly, we look at evaluating the alternative plan, questioning the impact that it would have on individuals directly and indirectly, assessing the pros and cons, and focusing on stakeholders to do this. There's also a look at benefit to the masses, and it should not harm any one group. Lastly, in implementing and monitoring the outcome. Although this bill was recently signed, it has already been held up in the courts. The current evaluation and monitoring is limited. However, one can see the voices that are opposed to this bill and those who are for this bill, and this will be the legislation monitoring that will occur over the next several months. Senate Bill 1391 was recently signed, and with less than 2 months of its effective date, the outcomes are limited due to the stakeholder responses. Since its enactment on January 1st, 2019, this bill has been challenged, starting with the Kern County Superior Court on January 18th, followed by at least 10 counties as of January 30th, 2019, including Riverside, Ventura, and Kern. It has been deemed unconstitutional because it did not further previous legislation, but rather went in the opposite direction. There are some counties, however, who support SB 1391 and find it constitutionally sound and fair. There are 3 recommendations posed in this presentation. The first strategy involves stakeholders. Stakeholders must have their voice heard in advocating for or against a bill, in this case SB 1391. Voices increase the opportunity for policy change. This bill, SB 1391, should be reassessed to make sure that all of the reasons and the justifications for the various sides of the argument are heard and that the best solution is made. Secondly, policy must advance previous effective policy and address the intended purpose of the legislation. There needs to be rehabilitation programs that can cater to the individual needs, as not all juveniles are the same and not every case is the same. SB 1391 was rolled out as a one-size-fits-all solution when dealing with minors with different backgrounds and who commit different crimes. The intended purpose needs to be evaluated and whether or not they are meeting the intended outcomes. Additional research needs to be done in this area. And thirdly, we need to address the root cause of the issues and include in the solution in order to have an effective policy. Policy must address the root cause, and we must recognize that one-size-fits-all approach is not effective. The root causes may include poverty, marginalization, and disenfranchisement. And if these are the issues that are at the root cause of juvenile crime, then policies addressing juvenile crime are going to do very little to solve the actual issue. Proposition 57 targeted minorities and therefore produced discrimination in convictions and incarcerations. So in any legislation that is produced, the outcomes, the results, the implications need to be carefully assessed and then monitored to make sure that there are no discriminatory policies that are in place that are going to target one group over another. From a Christian perspective, we will review what the Bible provides as reference on these issues and the direction it gives. The Bible has few references about crime and punishment. However, it does speak quite frequently about rehabilitation, judgment, and justice. The responsibility that is required when it comes to the use and limits of judgment and seeking justice is also referenced repeatedly in the Bible. The Bible also speaks often about forgiveness. One example in Genesis, Joseph is imprisoned by Potiphar, the captain of the guard for Pharaoh, yet the Lord shows him love and leniency and provides him direction, a way out. What is important to remember is that God is a God of justice and is the judge of all judges. We are accountable for our actions and are to use fair judgment and be responsible in the decisions that we make. And this applies to the justice system as well. In conclusion, in analyzing Senate Bill 1391, one can see the process it went through to pass into legislation, including influencers and stakeholders and the impact of previous legislation in place. From a Christian perspective, Senate Bill 1391 can be seen as an improvement upon Proposition 57 in that it centers around the belief of rehabilitation and fairness that was not resulting through Proposition 57. However, it is clear that Senate Bill 1391 has not fully addressed the issue of juvenile crime or the impact of juvenile crime. Even though the legislation has been recently implemented, it is imperative to take into consideration the three recommendations. 1. Reassess the stakeholder input and be intentional about listening for solutions. 2. Additional research is needed, as the literature in this area is minimal. What does the data say about whether trying youth as adults is effective in crime deterrence? And lastly, what are the root causes of juvenile crime? If policies are to be effective and a just and equitable system is to be formed, then root causes must be looked at and how these are being addressed or how can they be addressed. Thank you very much. These are our references. Thank you.